Morning, everybody. Our first case is State versus Gregory, and we will hear from the appellant.
Good morning, and may it please the court. My name is Kelly Manette, and I represent Kendrick Gregory in his appeal to this court. Before I begin, I would like to reserve 5 minutes of my time for rebuttal. This court in State v. Leggett held that the right to confront and cross-examine one's accusers is central to an effective defense and a fair trial. This court in State v. Bacon said that when it comes to expert witnesses, the largest possible scope should be given, and almost any question may be put to test the value of his testimony. Here, the trial court limited the scope of the cross-examination of the state's expert witness, Dr. Nicole Wolfe. She was the only witness to say that Mr. Gregory was not insane, and this limitation denied the jury the knowledge of a fact that shed light on the mental state of Mr. Gregory, and it deprived the jury of information that demonstrated Dr. Wolfe's bias. In the 2020 cell hearing that occurred, where the state was asking the court to allow forcible medication for Mr. Gregory to be restored to capacity to proceed, Dr. Wolfe testified. She testified about an incredibly mentally ill man, as mentally ill as a person can be. She testified about his hallucinations, her clinical observations. She testified about how he would not be restored to capacity without medication. He would not get spontaneously better, and that his mental illness could make him aggressive and a danger to himself and others if he was not medicated. At trial, only a year later, Dr. Wolfe testified about a calculating, manipulative man who malingered and feigned symptoms of mental illness for his own gain. These distinctly different descriptions are of the same patient. And ultimately, the trial court did not permit the defense to elicit the purpose of the prior hearing. The state, in their brief, points out how Dr. Wolfe testified that the difference in her testimony could be explained by the receipt of additional records. This is what she said at trial. Is sure, I testified differently at that cell hearing, but that was before I received a bunch of records. However, there were distinct differences in the same events in the way she talked about them. So, for example, in the cell hearing, she talked about how he described hallucinations and his description was corroborated by their clinical observation and seen to be indicative of genuine mental illness. That didn't change between then and trial, but at trial, she talked about how his description of his hallucinations being constant was indicative of somebody who was feigning. And she talked about how his description of or his comfort level with the hallucinations was indicative of somebody who was exaggerating or feigning symptoms of mental illness. These differences were extreme, yet she took something that should have undermined her credibility, the difference in her testimony, and she transformed it into something to show that she was an unbiased witness who changes her opinion with new information. Ultimately, the lack of the information about the context of the hearing somehow served to enhance her credibility when it should have undermined her credibility and shown her bias. I think it's important to talk about what was known when to highlight why her explanation was not sufficient. She saw Mr. Gregory many times, first in 2017 for a capacity evaluation. At that time, she had minimal records, some, but minimal, and she found him incapable of proceeding. In 2018, she saw him for both a capacity evaluation, at which time she found him capable of proceeding after being treated with antipsychotic medications, and then she further saw him for a state of mind assessment. This 2018 state of mind assessment was the basis of her opinion at trial that he was not insane at the time of the events. At that point in time, she had the benefit of psychological testing that demonstrated that there was some amount of feigning or exaggerating symptoms. Her reports note that, and they distinctly note that often a person with mental illness can feign or exaggerate symptoms, that these things coexist. And her reports talk about the feigning and exaggerating tending to happen at points in time in which he is medicated, not at points in time in which he is unmedicated. Further, in 2018, she received the Holly Hill records. Noted multiple times is the fact that he was hospitalized about 20 times in the 8 months prior to these crimes. Holly Hill served as the basis of the hospitalizations for about half of those. So as of 2018, she had about half of the records that were discussed at trial. Those records did note that clinicians had considered whether he was malingering or feigning symptoms at points in time. That's also noted in those 2018 reports. She notes in the 2018 mental status report that he reports hearing hallucinations all the time, hearing voices all the time. But again, she says people with genuine mental illnesses do feign symptoms at different points in time. In 2020, there was another capacity evaluation. At that point, she had another opportunity to interact with Mr. Gregory. And at that point, she found that he was incapable of proceeding, noting physical attributes that helped to corroborate his mental illness, being malodorous, neglecting basic hygiene, being seen responding to internal stimuli. 2020 was when the cell hearing occurred to attempt to forcibly medicate him. The cell hearing started in March of 2020, March 5th, I believe. It did not conclude. There was a plan to come back towards the end of the month to conclude the hearing. Of course, that's when the COVID pandemic occurred. By the time they reconvened, Mr. Gregory had started voluntarily taking his medications, eliminating the need for a conclusion to that hearing. In 2021, there was a capacity hearing with differing expert testimonies, and there was a new capacity evaluation. Then they proceeded to trial. And at trial, Dr. Wolf was the sole expert witness to say Mr. Gregory was not insane at the time of these events. That history is important to contextualizing and understanding why her bias was critical to pull out, why the fact of the purpose of that 2020 cell hearing was important. The trial court cited Rule 403 for the reason why the defense was not allowed to elicit that information. As we all know, Rule 403 says that if the unfair prejudice substantially outweighs the probative value, the trial court has the discretion to preclude the evidence, to preclude the information. As a defense attorney, I cite 403 a lot. I am constantly reminded in trial courts and appellate courts that the state's case is inherently prejudicial to my client. What we're talking about is unfair prejudice. Unfair prejudice. What is unfair about the information about the prior hearing? The state didn't cite any reason in the trial court. The trial court didn't cite any specific unfair prejudice in making its ruling. The Court of Appeals didn't cite any specific fact or circumstance or argument as to why this was unfair prejudice. Really, the first argument we have gotten is in the state's new brief at this court, and it's in a footnote, and it functionally says that speculatively, the jury could have had an emotional reaction to the idea that the state was attempting to forcibly medicate Mr. Gregory. Whether or not that is unfair prejudice, whether or not that it substantially outweighs the probative value of this information, that information, or at least somewhat, that information was already in front of the jury. Because in the 2018 capacity evaluation, on addendum page 892, this report had been admitted for the jury, and it details how under hospital protocol, because Mr. Gregory became paranoid on the unit and aggressive, he was started on non-emergency forced medication, and after that, he had no further episodes of aggression. So the jury already had information that the state hospital had used its own protocol to forcibly medicate him. So I repeat, what is unfair about this information? It is highly probative, as Judge Hampson noted, of both the mental state of Mr. Gregory and of the potential bias of Dr. Nicole Wolf. This jury worked really hard on this case. This trial took almost a month. The jury was out for a day and a half. They asked multiple questions. They reported being hung. This jury deserved to have all the information. They deserved to get that context that would enlighten them as to the credibility of the expert witness. Our case law requires for there to be effective cross-examination that draws out bias, particularly when it comes to expert witnesses, whose testimony is so important to a jury conclusion. Unfortunately, in this case, the jury did not get that information, and the work that they did not include an understanding of this information.
If I can ask you, if I understand the state's argument on what issue is precisely before us, they represent that only the Rule 403 issue is before us, that the dissent did not base its decision on confrontation clause considerations. And what is your response to whether or not the confrontation clause constitutional issue is before us based on the dissent in this case?
Absolutely. This part of the state's brief was an incredibly labored attempt to try and dodge and weave around all of these barriers to their conclusion that there is no constitutional issue. There is no case that says that a limitation on the right to, or a limitation on cross-examination in a criminal matter does not implicate the Constitution. There's no case. So the state starts by arguing that because the standard of review is abuse of discretion, that indicates that it's not constitutional because constitutional cases get de novo review. That is not the way that this works in our case law. Our case law says that an entire denial of the right to confront and cross-examine is reviewed de novo. And the case cited by the state, that is what that case is about. So if this expert report had been admitted without Dr. Wolf's presence, it would be a de novo standard of review. But because cross-examination was allowed and limited, we review that for abuse of discretion. That is what Davis v. Alaska did. That is what Bowman did. And so this is well-established case law that a limitation on cross-examination is reviewed for an abuse of discretion. That is the standard of review I have always alleged applies in this case. I have never said that it was a de novo standard of review. Nobody has said that.
But does it have implications then, assuming that we were to find that it was error not to allow the defense to cross-examine about the purpose of the prior arguably inconsistent testimony of this witness, if we were to find that it was error, does the fact that we're reviewing this as a constitutional claim impact the question, the standard we apply to determine whether it was harmless error?
And yes, so where we get with this is that the state alleges that it should be a statutory prejudice analysis rather than a harmless error analysis. I will say I think in this case, that is immaterial. The prejudice is not the battleground here. This was the whole case, the whole month of trial was about whether or not Mr. Gregory was insane at the time. And this is the one witness who says he was not insane. Her credibility, the fact that the jury could have believed her to be a less credible witness with this information, rises to both of those standards. However, the correct standard to apply is harmless error, because our case law has found that an improper limitation on cross-examination does implicate the Constitution. And in fact, in Judge Hampson's dissent, he cites Davis v. Alaska, which is constitutional case law, and the quote he uses talks about the right to cross-examine. And the right to cross-examine is the constitutional right to confront the witnesses against you. And so all of this dodging and weaving that the state does feels like a distraction from the real issue in this case. And ultimately, I would submit, somewhat immaterial one because prejudice doesn't feel like the place where the argument belongs.
So is your position that there's really no way a court could rule in, let's say, a 403 issue involving a state witness without also, and if that was an error to not permit that line of questioning, that it would, there's no scenario where it would not also be a violation of the Confrontation Clause?
Our case law has never found that an improper limitation on cross-examination in a criminal case doesn't implicate the Constitution. So when the judge abuses their discretion in limiting cross-examination, it is in fact a violation of the Confrontation Clause. This is where the statutes and the rules of evidence intersect with the Constitution. We just have to get to that higher standard review because some amount of cross-examination was allowed here. So it's not a total deprivation of the right, it's a limitation of the right. So we give a lot of deference to the trial court.
So suppose we agreed with you about that, wouldn't there still, though, be the requirement that in order to get the heightened standard, prejudice standard that applies to constitutional claims, you would have to inform the trial court that you were making an objection on constitutional grounds? Do you agree with that?
I completely agree with that, and they did here.
So my question is then, when we're looking at the dissent in this case, would we not also have to have jurisdiction over the constitutional question, also be able to look and see something in what the dissent is saying and say, aha, here is an argument that this violates the Confrontation Clause? Where do we find that in the dissent, would you say?
I would say we find that very clearly in Davis v. Alaska citation, both in using Davis v. Alaska, which is a seminal Confrontation Clause question, but then also in the actual quote from Davis being used by Judge Hampson that cites the right to cross-examine. The right to cross-examine. And our case law has said the right to cross-examine is implicit in the Confrontation Clause. These are the same. They're the same words. So I think what Mr. Dunn has suggested is that there are magic words, and I don't think there are magic words that a judge in the Court of Appeals has to use when all of our case law talking about limitations of cross-examination are constitutional, and in which constitutional case law is used to support the reasoning, have to use specific magic words to ensure that that is what is brought before this court. There was enough here, more than enough, to say that the constitutional issue is before this court.
So the defense was able to cross-examine Dr. Wolf regarding inconsistencies between her testimony at the cell hearing and at trial. And you've told us that the jury had other evidence before it that indicated forced medication. How do those things together not equal no real prejudice?
Thank you. That's a great question, Justice Allen. The issue is that the context in which Dr. Wolf was testifying is what really demonstrates her bias. She talked about the same thing so differently in the two hearings that a juror easily could have found that she came in not as an unbiased expert witness to give the information and her conclusions and step away, but rather as an advocate for her positions. And she does this at the cell hearing by focusing on the mental illness of Mr. Gregory, how extreme it was, how it could never, ever be controlled without this forcible medication. And I think there's a quote in a question and an answer in the transcript for the cell hearing that just really highlights this. She was asked, why is it appropriate that he receive antipsychotic medications against his will? Go through that cost-benefit analysis for us. And she said, well, he is not going to spontaneously improve without treatment. The other thing is that there are significant risks with a lack of treatment. Psychotic people do unpredictable actions, and sometimes there's dangerousness to self or others. So untreated psychosis can lead to suicide, not uncommonly, and can also lead to aggression. This is in direct contrast to how she describes Mr. Gregory and how calculating he is when we all agree he was not on his medication at the time of these events. He had been off medication for at least 6 weeks at the time of these events. And here she's saying he cannot spontaneously improve. The change in opinion, when you understand the context of this hearing, appears to be somebody who is advocating her position, taking bits and pieces of information and bolstering her opinion by talking about them in different ways for different purposes. And you don't understand that if this is just some prior testimony, especially where she claims that the difference is she received additional records in between the two. She explained away the differences. But understanding the context of the hearing really undermines that explanation significantly. And she comes across in this transcript as somebody who is advocating.
And so you're saying, even though the jury might have known that there was some effort to medicate him against his will, they didn't know that this testimony that she gave about how mentally ill he was and that he couldn't get better without medicine, they didn't know that that happened in a hearing at which the question was whether or not he'd be medicated.
Exactly. Her opinion at that hearing was that he needed to be forcibly medicated. His will needed to be overborne, and he needed to be forcibly medicated for two reasons, and two very critical reasons. One, he would never be capable without the medication. And two, he was a danger to himself and others. Both of those reasons are pretty critical for the ultimate analysis of whether or not he was insane at the time of this event. They are different standards, but this is a circumstance that sheds light on his mental state at the time of the offense. It is also the fact that she was motivated to get him restored to capacity. And she said these things with that motivation. But then at trial, where she wanted to support her position that he was not insane, she focuses on the malingering and the feigning and calls him a deliberate, calculating individual who uses mental health symptoms for his own gain. I mean, these are extremely different patients she's talking about.
Can I ask a clarifying question? Is it your position that the jury's understanding of the forced medication that had happened up to that date was entirely at the initiative of the hospital instead of the state?
That is correct. And at the cell hearing, there was discussion about hospital protocols on forced medication, and that the hospital has the right to forcibly medicate patients for specific reasons. That was an example of forced medication that the hospital had engaged in because of his aggressive behavior while he was a patient on the ward. And my point in bringing that up is not to say that, my point in saying that this is a ripe area for cross-examination is not to have a discussion about whether forced medication is appropriate, but rather to show the motivation of Dr. Wolf in that hearing and to shed light on the mental health of Mr. Gregory. The only argument we've gotten about the unfair prejudice has to do with the fact that the term forced medication could cause emotion, but that term was already in front of the jury. So to the extent that that might cause some emotional reaction of jurors, that bridge had already been crossed. And so it's hard to see how that supports this being unfair, especially when it's critical to understand why Dr. Wolf testified so differently. If there are no further questions, I will reserve my remaining time.
Actually, Counselor, before you go, I do have one. I understand your argument about the bias, but I'm looking at the transcript and I'm having trouble finding where the defense actually let the court know that they were concerned about bias, as opposed to this information going to the state of mind, his insanity at the time. Can you point me to where I can find that?
So the defense constitutionalized their objection under multiple constitutional objections and under the state constitution, which covers all confrontation clause issues. I think a lot of the specific arguments were about shedding light on his mental state and his mental illness, but both issues were discussed in the dissent, and that is where we are here.
And that I see that, but what I'm focusing on really is it was discussed in the dissent, if we accept your argument. But is it not true that the trial court at least needed to have the opportunity to address the bias in front of it? Was it not the prosecutor's responsibility to call that to the attention of the trial court so it could have been taken into account in this in the trial court's analysis?
Did you mean the defense attorney?
Yes, my
Okay.
apologies. Yes, absolutely. Thank you for the correction.
I just want to make sure I was understanding the question. So the proffer happened very quickly. The judge sustained the objection quickly, struck the question, I believe, then moved into the proffer. The proffer elicited all the proper information that would have shown the bias. The arguments were very brief. I don't know that the word bias was used.
I can't find it
Yeah.
there.
So I don't know that the word bias was used, but I do think this particular sub-argument is preserved under the objection that constitutionalized everything, and the proffer that elicited the information that would have shown her bias.
Thank you, Counselor.
Thank you. If there are no further questions, I reserve my remaining time.
Thank you, counsel. We'll hear from the appellee.
Thank you. Good morning, Your Honors, Mr. Chief Justice, and may it please the court, Zachary Dunn here on behalf of the state. This case is not about whether a defendant was entitled to cross-examine Dr. Wolf about the differences between her testimony at the cell hearing and her subsequent testimony at trial. He was entitled to do so, and he did do so. The issue in this case is much narrower: whether the trial court abused its discretion in disallowing two discrete pieces of information. One, the fact that a cell hearing occurred, and two, that the state attempted, but ultimately did not, forcibly medicate defendant in order to restore his capacity to proceed to trial. The Court of Appeals correctly held that the trial court did not abuse its discretion, both because those pieces of information were irrelevant under Rule 401, and in the alternative substantially outweighed by the danger of unfair prejudice under Rule 403. As this court has reiterated throughout the years, although cross-examination is a matter of right, the scope of cross-examination is subject to appropriate control in the sound discretion of the trial court. That's from Coffey. And of course, this is reviewed for an abuse of discretion. This court is well aware that in order to find an abuse of discretion, this court must find that the ruling was so arbitrary that it could not have been the result of a reasoned decision. And as I began at the top, the limitation on cross-examination here was extremely modest. The only limitation was on defendant's ability to mention the fact that a cell hearing occurred and that the state sought to forcibly medicate, but ultimately did not forcibly medicate defendant in order to restore his capacity. This information was not relevant under Rule 401. Although the trial court did not make a Rule 401 determination, the Court of Appeals held that the fact that a cell hearing occurred or that defendant may have been subject to forced medication was not probative in any way. That's from the Court of Appeals ruling in this case, and that's true. The issue before the jury had nothing to do with forced medication. It was not an issue that the jury was tasked with deciding. And so the first way...
If it's the same witness, so I can imagine a number of scenarios where it's a different expert witness at the cell hearing. What I didn't understand from the Court of Appeals majority's explanation is, how is that not in some way probative of bias when the same expert witness relied upon by the state at trial has previously opined that this man was so sick that he needed to be forcibly medicated and that the state, rather than anyone else, was the one who should do it? I mean, doesn't that affect how the jury perceives her, how the defense is allowed to portray her bias?
Well, I think that the jury, knowing about the state attempting to forcibly medicate the defendant, would have introduced unfair prejudice to the state. But the jury did know about the differences between her testimony at the cell hearing and the testimony at trial. There was extensive cross-examination by defense counsel. And although the name of the cell hearing and the reason for the cell hearing was not before the jury, all of her testimony at the cell hearing was in front of the jury. The first question that the defense counsel asked after the objection was sustained was, quote, "We were talking about a hearing that occurred in March of 2020, which was the cell hearing. And then, is it fair to say that you probably have testified quite a few times?" So the jury was aware, and the defense was able to elicit the differences between her testimony at the cell hearing and at trial.
But as I understand the record, as I understand it, she testified that the reason that her testimony had changed was because she got new records. And if the defense had been allowed to let the jury know that the purpose of that hearing was a very different purpose than what she seemed to be testifying for at trial, that's additional information the jury should have in order to weigh the credibility of her assertion that she dramatically changed her assessment of this individual based on medical records.
Well, and I will say the defense, of course, was aware at the time of trial which record she had when. So they were able to elicit that testimony from Dr. Wolf. You say you got more medical records and that's why you changed your mind, but here in this report in 2017 and in 2020, it shows that you had these records. So, they were able to elicit that information without the unfair prejudice of knowing that the state sought to forcibly medicate the defendant.
But they weren't able to elicit the information that when she testified in March of 2020, the state was seeking a ruling that this man was so ill he ought to be medicated against his will. And then at trial, they were eliciting her testimony in order to establish that he was not mentally ill at the time of these offenses, even though he wasn't medicated.
That's true. And our position is simply that the forcible medication question was not an issue before the jury, and so it was irrelevant under 401.
But her credibility is an issue before the jury.
Her credibility is definitely an issue before the jury. But as I think Justice Allen elicited, or maybe it was Justice Berenger, the crux of the argument before the trial court was not predicated on trying to attempt to show her bias. That was not the objection that was made, or the arguments during the objection that was made at trial.
How important is it that, if I understand the timeline correctly, the crimes occurred in 2015?
That's correct.
The cell hearing is 2020. And what Dr. Wolf is addressing at the cell hearing is whether the defendant should be forced to take medication in order to be competent to stand trial, not whether the defendant was legally insane at the time of the offenses. At trial, she's addressing his whether he was insane at the time of the offenses in 2015. How should that inform, am I right about that? And how should that inform our analysis?
That is correct. I believe your timeline is correct. The offenses were 2015. The first time that Dr. Wolf saw the defendant was in 2017, and then the cell hearing was in 2020. But you're absolutely correct, and we cite those cases. It's the Clark and Willard cases in our briefs, that there is a major difference between, on the one hand, whether a defendant is capable to proceed to trial, and on the other hand, whether he was legally insane at the time of the offenses. And so really her testimony about forced medication is about something 5 years in the future, speaking from when the offense occurred. It's not about what he was, how he was at the time of the crime. And that is a difference that Dr. Wolf made in her testimony, and it's rooted in this court's case law, that those are two very different standards. And so we would say that's highly relevant. And the fact that she was testifying at the cell hearing about capacity to proceed really doesn't shed much light about whether he was or was not legally insane at the time of the crimes.
So to sort of put it another way, there's no inherent inconsistency in saying you're not competent to stand trial, but you were legally sane 5 years previously when you committed the offenses that are at issue.
That's correct, yeah. We don't think that there's any inconsistency in that.
Let me ask about what you just said flipped around. So if the jury was already hearing from Dr. Wolf that there's two different standards, capacity to stand for trial and insanity at the time of the offense, I mean, that wasn't something that the jury was going to be shocked by if the purpose of the cell hearing came in, right? I mean, it's understood and explained to the jury that a person who may previously be incompetent to stand trial can be brought into competency either through medication, or sometimes maybe there's a kind of disease that does spontaneously just improve. And so this goes to the state's assertion of unfair prejudice, which is I don't understand where the unfair prejudice came in if the jury was already being instructed and explained, and Dr. Wolf was testifying about the different standards of her analysis.
Right. So the unfair prejudice is, and this comes from a case from this court, De Leonardo. It's an undue frequent tendency to suggest decision on an improper basis, commonly, though not necessarily, an emotional one. And so even if, and through the report, the jury was aware that at one point the hospital attempted and did forcibly medicate him, it's a whole other thing for the jury to know that the state itself was trying to forcibly medicate him. And so there is that likelihood that the jury would, it would be a confusion.
Why is it different? Why is it different? Because I think I'm just approaching this from a different way. I mean, if you're saying there's something so emotional and questionable about the state seeking to medicate a person, and it's the same witness who says forcibly medicate him, oh, he was malingering, how is that not conceding a bias issue?
We just, our position is that the jury knowing about forcible medication would have confused the issues and unduly prejudiced the jury against the state. And we're talking about, again, something, and this is flipping it, I suppose, back around, something that happened 5 years after the crime, and with those different standards. I will say that the jury was well aware of Mr. Gregory's mental illness. They knew that he was not medicated at the time of the crime. They knew that he had been prescribed medications by Dr. Wolf and other doctors to help treat his mental illnesses, and that Dr. Wolf had previously testified that medication was necessary in order for a defendant to maintain capacity to proceed to trial. So really it is a modest limitation on two things: the fact that a cell hearing occurred and the forcible medication issue. I did want to touch on the constitutional issue for a moment.
Can I just follow up, though, before you go there? I certainly understand the point that there's a distinction between capacity to proceed at trial and whether or not his mental state at the time he committed the crimes was such that he's, legally considered insane. And I understand that difference, and that there's not necessarily a contradiction in her testimony that he could have been not competent to stand trial at a later date. But I understood the inconsistency here to be about the question of whether or not he was genuinely mentally ill or whether he was malingering. And that's the inconsistency in her testimony that the jury was entitled to consider when they weigh whether or not she was truthfully testifying about his mental state.
Well, I believe that's correct, but that did come out during Dr. Wolf's testimony at page 2839 in the record. The defense counsel began asking Dr. Wolf about malingering and the concept that someone can have a legitimate psychological diagnosis and also malinger symptoms. So that was something that was before the jury. In her testimony at trial, she said, of course, that he was malingering, and that stands in stark contrast to her previous testimony that was highlighted by Ms. Bennett, that he, quote, was not going to spontaneously improve without treatment. Right. And so that distinction was in front of the jury.
Right, but isn't the question, she explains her change in opinion about him based on getting new medical records. And if the jury was able to understand the context, not the fact of the cell hearing, but the context in which she gave that testimony, the prior testimony, they would be in a better position to assess whether or not she was being credible.
Well, the only thing that was kept from the jury was the fact of the cell hearing and the fact the state attempted but ultimately did not forcibly medicate the defendant. So they were able to extensively cross-examine Dr. Wolf about the inconsistencies and the differences in her opinion and her testimony between the two hearings. And because forced medication was not an issue before the jury, we think it was irrelevant under Rule 401 and then unfairly prejudiced under Rule 403. I did want to quickly talk about the Confrontation Clause issue. We agree, even if this court believes that the Confrontation Clause issue, the constitutional issue, is before this court, it essentially works out the same way. However, we made the point in our brief not to dip and dive and that sort of thing, but because the rules they've since been changed to remove automatic right of appeal based on dissent. But at the time, it said that it must be the matters embraced by the dissent, and the dissent did not talk about the Constitution. Yes, Judge Hampson did cite to Davis versus Alaska, which is a constitutional case, a Confrontation Clause case, but he, in his dissent, never said, I believe that the majority errs here because I would find that the limitation on cross-examination violated the Confrontation Clause. So we just think it's not something, I'm sorry.
But just to ask you about that, in addition to citing from Davis v. Alaska, he also says that defendant had the right to place before the jury testimony through cross-examination. How could that right to place before the jury testimony through cross-examination be anything other than a Confrontation Clause right?
Well, I think it goes to this court's statement in Coffey. You know, cross-examination is a matter of right, and the scope of cross-examination is subject to control at the sound discretion of the trial court.
Right,
So,
but what is the source of that right?
well,
not the
Coffey doesn't
Confrontation
say, but I believe it's just a matter of North Carolina law. Although, even if, again, we believe that the result in this case is not affected by whether or not this court believes that the Confrontation Clause, the constitutional issue, is before it. But we did want to make the point that if Judge Hampson wished to base his dissent on the Constitution, it would have been no problem to say, I believe this violated the Constitution. And then on the constitutional issue, I did want to talk about the harmless beyond a reasonable doubt standard. Even if this court believes that the Confrontation Clause is before it and that this testimony or this limitation on cross-examination was a violation, we believe that it was harmless beyond a reasonable doubt under 15A 1443B because of, again, it was a very modest limitation on cross-examination, just the fact of a cell hearing and the issue of forced medication. The jury was well aware of the inconsistencies in Dr. Wolf's testimony. They knew that the defendant had a serious mental illness and that he was unmedicated at the time of the crimes. And as my friend on the other side mentioned, they knew that he had been forcibly medicated at one point in time, although they didn't know that the state was one of the entities seeking to forcibly medicate him. So,
Can I ask you, is it the state's position that the fact of the questions the jury sent out and the being hung at one point, does that never factor into the state's burden to prove beyond a reasonable doubt harmless error, or does it not factor into our analysis in deciding whether there was error?
we certainly think that it can factor in. That's something that this court can consider. I mean, it's a matter of the record. They were sending out notes. I believe that they said that they were a hung jury at one point. That is something that they can consider. But we think on balance, because of the modest limitation on cross-examination and all the other evidence that the jury had, that it balances out to no harmless beyond a reasonable doubt. Unless there are any further questions.
Well, I did want to make one point about the citation to Davis in the dissent. It's not just a citation. I mean, it's a block quote
Correct.
on the purpose of cross-examination. So certainly, do you concede Davis is talking about the confrontation, the right under the confrontation clause?
We do, certainly. I mean, it's a block quote. That is what it's discussing. Our only point, and again, maybe we perhaps spent too much time on it on the brief, and if we did, I apologize. But the dissent itself, Judge Hanson did not say, I believe that this is a violation of the Constitution. But if your honors believe that that matter was embraced by the dissent, we think that's totally fine. We think it shakes out the exact same way. Thank you. We would ask this court to affirm the judgment below.
Thank you, counsel. Rebuttal.
I do want to address a couple of the points that were raised. First, and I don't recall who was having the discussion, but there was discussion about the fact that the records, I think it was Justice Allen, the records and what was before Dr. Wolf at different points in time was available and could have been cross-examined on and maybe was cross-examined on. And isn't that sufficient to show that her claim that she changed her opinion with new information was not a good one? And I do want to respond to that because the problem is if you don't, as a defense attorney, if you don't have an alternate explanation available, that impeachment is meaningless. So if I can't say to a jury, this is why I think she changed her testimony, then impeaching her is not nearly as effective. So saying you had some records at this time is not nearly as effective if I'm not able to say, this is why I think you changed your opinion. And that was not available to the defense. I do want to talk for a minute about the differences in standards between capacity and insanity. We know that those are different standards. Our case law is clear that those are different standards, but our case law is also clear that orders of incapability are admissible, and this is under Buntridge, it is longstanding law in North Carolina, as a way of shedding light on the mental state of the defendant in an insanity case. There is an understanding that despite there being different standards, this is helpful information for the jury. And so in the cell hearing in 2020, when she is saying that he is not able to be capable unless he is medicated, that is relevant information that continues to shed light on his mental state. And there being 5 years between the crime and that 2020 cell hearing might be an effective counterpoint to the weight of that information if there was any information that his mental illness had gotten worse or had come upon him in those 5 years. That is not the case. This is a man who was hospitalized 20 times in the 8 months prior to this event. This is a man who was found incapable of proceeding at every point pre-trial where he was not medicated. The first being 2017, just 2 years after these crimes. And so his mental illness was well established at the time of the crimes. There's no evidence, not even from Dr. Wolf, in front of the court that his mental illness substantially changed between 2015 and 2020, such that that diminishes the value of that information. All of this time, and with all of these opportunities, the state still fails to present a compelling reason that the information sought to be used was unfairly prejudicial. This information, which Judge Hampson correctly referred to as perhaps the most critical information about the cell hearing, was withheld, obliterating the defense's ability to meaningfully impeach Dr. Wolf on her bias and hiding information relevant to the defendant's mental state. I ask that you reverse the Court of Appeals and remand this case for a new trial where the jury will get the information they need to correctly weigh Dr. Wolf's opinion. Thank you.
Counsel, Mr. Clark.
All right.